The sound of the mall splitting through oak is one of those simple pleasures that city people never understand. And that Saturday morning in October 2024, I was enjoying every swing while watching the steam rise off my coffee mug on the back porch of my Asheville, North Carolina home. I'm Quentin Lawson, and I'd been splitting firewood on weekend mornings since I moved into the Meadowbrook Estates subdivision 3 years ago. My property backed up to the tree line, giving me plenty of privacy from the main road, and I'd always been careful to keep reasonable hours. Never before 9 in the morning, never past 6 in the evening, and only on Saturdays or Sundays when I actually had time off from my job as a structural engineer downtown. That particular morning, I was working through a cord of seasoned red oak I'd had delivered the week before. Winter was coming early according to the forecasts, and I wanted to make sure I had enough split and stacked for my wood-burning stove. The rhythmic thwack of steel on wood was almost meditative, and I'd been at it for maybe 45 minutes when I heard the gate to my backyard creak open. I turned to see Patricia Henderson marching across my lawn like she owned it. Patricia was the president of the Meadowbrook Estates Homeowners Association, a position she'd held with an iron fist for the past 7 years. She was 52 years old with that distinctive haircut that seemed to be required for women in her position, short and angular, dyed an unnatural shade of blonde that didn't quite match her dark eyebrows. "Mr. Lawson," she called out, her voice sharp enough to cut glass. "We need to talk about this noise disturbance you're creating." I set down my splitting maul and wiped the sweat from my forehead with the back of my work glove. "Morning, Patricia. What noise disturbance would that be, this?" She gestured dramatically at my woodpile and the chopping block. "This incessant banging every single weekend. Do you have any idea how many complaints I've received?" I took a slow breath, trying to keep my tone level. "I'm splitting firewood on my own property during reasonable daylight hours. I fail to see the problem." Patricia pulled out her phone and began scrolling through it with theatrical precision. Section 8, Paragraph 4 of the HOA covenant clearly states that homeowners must not engage in activities that create excessive noise or disturb the peaceful enjoyment of neighboring properties. "It's 9:15 on a Saturday morning," I said. "I'm not running a jackhammer. I'm splitting wood for my fireplace." "The covenant doesn't specify what type of noise," she countered, her lips pressing into a thin line. "Several of your neighbors have complained about the repetitive banging disturbing their weekend relaxation time." I looked around my backyard, noting that the nearest house was a good 100 feet away on one side, separated by a thick row of evergreens, and the other side was even farther. "Which neighbors specifically?" "That's confidential information." "Convenient." Patricia's face flushed red. "Mr. Lawson, I'm trying to resolve this matter amicably. If you would simply agree to discontinue this activity, we can all move forward peacefully." "And what am I supposed to do?" "Buy pre-split firewood at 3 times the price. Freeze this winter." "That's not the association's concern. Our concern is maintaining property values and ensuring all residents can enjoy their homes without disruption." I picked up my coffee mug and took a long sip, considering my options. "Patricia, with all due respect, I'm not breaking any laws. I'm not violating any noise ordinances. The city of Asheville allows this type of activity between 7 in the morning and 10 at night. I'm well within my rights. The HOA covenant supersedes city ordinances in matters of community standards," she said, raising her chin. "You signed that covenant when you purchased your home." "I'll tell you what," I said, trying to find a middle ground I knew probably didn't exist. "How about I limit it to just Saturday mornings, 10 to noon? 2 hours once a week. That's more than reasonable." Patricia shook her head. "That's not acceptable. The activity needs to stop entirely." "Then I guess we have a problem because I'm not stopping." Her eyes narrowed. "Then you leave me no choice but to issue a formal citation and fine. $50 for the first offense, doubling with each subsequent violation. You do what you need to do, Patricia. I'll see you at the next HOA meeting." She spun on her heel and marched back across my lawn, her sensible pumps leaving small divots in the grass that I'd have to fix later. I watched her leave, feeling the familiar tension in my shoulders that always came from dealing with the HOA. This wasn't the first time we'd butted heads. There had been the great mailbox controversy of 2022, when I'd replaced my rusted mailbox with one that was apparently 3 inches too tall, according to the covenant. Then there was the incident with my fence being stained the wrong shade of brown, resulting in a 2-month back-and-forth battle that ended with me having to restain the entire thing. But this felt different. This felt personal. I went back to splitting wood, partly because I needed to finish the job and partly because I wasn't about to let Patricia Henderson dictate what I could do on my own property. The maul felt heavier in my hands now, each swing punctuated by my growing frustration with the entire HOA system. 4 days later, I found the violation notice in my mailbox. It was printed on official HOA letterhead, complete with the Meadowbrook Estates logo at the top, a ridiculous clip art image of a house with a sun rising behind it. The letter formally cited me for violating Section 8, Paragraph 4 of the covenant, and assessed a $50 fine payable within 30 days. It also included a cease and desist order, demanding that I immediately stop all wood-splitting activities on the property. I called my buddy Derek that evening. Derek Martinez was an attorney who specialized in property law, and we'd gone to NC State together back in the day. He listened patiently while I explained the situation over beers at the Wedge Brewing Company downtown. "So she's claiming your normal property maintenance is a noise violation," Derek said, setting down his IPA. "That's going to be tough for her to enforce. Can she actually do this? Can the HOA really tell me I can't split firewood on my own land?" Derek tilted his hand back and forth in a so-so gesture. "It's complicated. HOAs do have broad authority to enforce their covenants, but those covenants can't violate state law or your fundamental property rights. North Carolina has some pretty strong property rights protections, and reasonable use of your property for normal activities is generally protected. So what do I do? Just ignore the fine?" "No, don't ignore it. That'll just escalate things and give them ammunition. Here's what I recommend. Write a formal response disputing the citation. Reference North Carolina General Statute 47F, which governs HOAs in the state. Specifically note that your activity is a reasonable use of your property, doesn't violate any noise ordinances, and is being conducted during reasonable hours." And if they don't accept that, Derek grinned, "then we take it to court, which, honestly, I think you'd win. But it's a hassle, costs money, and takes time. Try the formal response first." I spent that weekend drafting my response, carefully citing the relevant statutes and explaining in detail why my wood-splitting activities were reasonable and legal. I noted the times I conducted the activity, the frequency, and the fact that I'd received no direct complaints from any actual neighbors, only from Patricia Henderson herself. I sent it certified mail to the HOA board on Monday morning. The response came faster than I expected. By Friday, I had another letter from Patricia, this one even more formal than the first. The board had reviewed my appeal and denied it. The fine stood, and if I continued the prohibited activity, additional fines would be assessed. Furthermore, if I failed to pay the fines, the HOA could place a lien on my property. That last part got my attention. A lien was serious business. It could affect my ability to sell the property or even potentially lead to foreclosure if left unpaid long enough. I called Derek again. "They're doubling down," he said after I read him the letter. "Not surprising. HOA boards hate backing down because they think it makes them look weak. Here's the thing though, they're on shaky legal ground. Want me to send them a letter on firm letterhead. How much would that cost me?" "For you, consider it a friendly favor. I'll draft something professional that lays out the legal framework and suggests they might want to reconsider their position before this ends up in front of a judge." Derek's letter went out the following Monday. It was 3 pages of dense legalese that basically said the HOA was overreaching its authority, and that I was well within my rights to split firewood on my property. It referenced multiple North Carolina court cases where similar HOA restrictions had been struck down, and it strongly suggested that pursuing this matter would likely result in the HOA not only losing but potentially being liable for my attorney fees. I thought that might be the end of it. I was wrong. The next Saturday morning, I was back outside splitting wood. I figured if they were going to fine me anyway, I might as well continue doing what I needed to do. I was about 20 minutes into my work when a Buncombe County Sheriff's deputy pulled up in front of my house. My stomach dropped. I walked around to the front yard, still holding my work gloves, and met the deputy at the curb. He was young, maybe late 20s, with the tired eyes of someone working the weekend shift. "Morning, officer. Is there a problem?" He checked his notepad. "Are you Quentin Lawson?" "I am." I received a noise complaint about this address, excessive noise disturbing the peace. I felt my jaw clench. "Let me guess. Patricia Henderson called it in." The deputy's expression didn't change, but I caught the slightest flicker of recognition in his eyes. "Someone called in a complaint. I'm required to respond. What are you doing that might be generating noise?" "I'm splitting firewood in my backyard. It's 9:30 on a Saturday morning." He glanced at his watch, then at my house, then back at me. "Can I take a look?" "Absolutely." I led him around to the backyard and showed him my setup. The chopping block, the maul, the cord of wood I was working through. He looked at the neighboring properties, noting the distances and the tree lines. "How long have you been at it this morning?" he asked. "About 20 minutes. "And you do this every weekend?" "Just Saturdays, usually. Sometimes Sunday if I didn't finish. Never more than a couple hours." The deputy nodded slowly, making notes on his pad. "Mr. Lawson, I'm not going to cite you for anything. This is reasonable activity during reasonable hours. However, I do have to document that I responded to the complaint. My recommendation would be to try to work something out with whoever called this in. The HOA president is the one who's been on my case about this. She issued me a fine and told me to stop completely." He sighed, and for a moment, the professional mask slipped. "Yeah, I've dealt with HOAs before. Look, you're not breaking any laws. The city noise ordinance allows this type of activity from 7 a.m. to 10 p.m. If she calls again with the same complaint, we'll note that it's been investigated and found to be baseless. But I'd suggest maybe documenting your activities, keeping a log of when you do this and for how long, just in case things escalate. Thanks, officer. I appreciate you being reasonable about this." After he left, I stood in my backyard for a long moment, anger simmering in my chest. Patricia had actually called the police on me for splitting firewood. This had crossed a line from annoying to absurd. I finished my work for the day, split and stacked the last of the rounds I'd been working on, and went inside to call Derek. He answered on the 3rd ring, and I could hear the sounds of his kids playing in the background. "She called the cops on me," I said without preamble. "The HOA president." "Yeah, noise complaint. The deputy was cool about it, said I wasn't doing anything wrong, but still. She actually called the police. Derek let out a low whistle. That's escalation. Okay, here's where we are. The HOA has issued you a fine that you're disputing. They've rejected your appeal. You have two options. Pay the fine and stop splitting wood, or fight it. If you want to fight it, we need to file in small claims court to challenge the fine and the HOA's authority to restrict this activity. What are my odds? Honestly, pretty good. Like I said before, this is a reasonable use of your property. The activity isn't prohibited by law, doesn't violate any actual ordinances, and is being conducted during normal hours. The HOA's covenant is overly broad if it's being interpreted to ban this kind of normal property maintenance. How much are we talking for legal fees? Small claims is designed to be accessible. Filing fee is around $200. I can represent you, but honestly, you might be better off representing yourself in this case. It's straightforward enough, and judges in small claims tend to be practical people who don't like HOA overreach. I can coach you through it. What about them putting a lien on my property? They'd have to win a judgment first. File your claim before they can escalate. That puts you on the offensive rather than the defensive. I made my decision. Let's do it. I'm not paying a fine for splitting firewood on my own property, and I'm sure as hell not letting them dictate what reasonable activities I can conduct on land I own. Derek talked me through the process of filing a small claims complaint. I spent the next few days pulling together my evidence. Photographs of my property showing the distances to neighboring houses. A log I started keeping of exactly when I split wood and for how long. Copies of the Asheville noise ordinance. The deputy's report number from his visit. And printouts of the relevant North Carolina statutes that Derek had referenced. I filed the complaint on a Wednesday morning at the Buncombe County Courthouse. The clerk was efficient and unbothered by the nature of my case. Apparently, HOA disputes were common enough that mine didn't even warrant a raised eyebrow. I paid my filing fee and left with a court date set for 6 weeks out. The HOA received their notice of the lawsuit within a few days. Patricia's reaction was predictable. She sent me an email, copying the entire HOA board, claiming I was wasting everyone's time and money with frivolous litigation. She also increased my fine to $100, citing continued violations. I forwarded the email to Derek, who actually laughed when he read it. She's helping your case. This looks retaliatory and heavy-handed. Make sure you print this and bring it to court. The next few weeks were tense. I continued splitting wood on Saturday mornings, and each time I did, Patricia would drive by my house slowly, sometimes stopping to take photographs. It was intimidating behavior, clearly meant to make me uncomfortable, but I documented every instance. Derek had suggested I set up a simple security camera covering my backyard, so I installed one that uploaded footage to the cloud. The HOA board held an emergency meeting 3 weeks before our court date. I received notice of it, as required by the bylaws, and decided to attend even though I knew it would be uncomfortable. The meeting was held in the community clubhouse, a small building near the neighborhood entrance that hosted everything from book clubs to yoga classes. When I arrived, about 15 other homeowners were already there, along with the 5 board members. Patricia sat at the head of the table, flanked by her vice president, Roger Chen, and the secretary, Barbara Whitmore. The treasurer, Tom Fitzgerald, and the at-large member, Susan Rodriguez, completed the board. Patricia called the meeting to order and immediately launched into a presentation about my ongoing violations of the community standards. She had prepared a PowerPoint presentation, complete with photos she'd taken of me splitting wood, complete with red circles and arrows as if I was committing some heinous crime. "As you can see," Patricia said, clicking to a slide showing me mid-swing with the mall, "Mr. Lawson has flagrantly disregarded our attempts to resolve this matter peacefully. He has ignored our citations, refused to pay his fines, and has now filed a frivolous lawsuit against the association, which will cost us all money in legal fees." A few of the homeowners murmured at this. I'd been waiting for my chance to speak, and now seemed like the right time. I raised my hand. Patricia's eyes narrowed. "Yes, Mr. Lawson," I stood up, keeping my voice calm and measured. "I'd like to address some of what's been said. First, I haven't ignored anything. I filed a formal appeal of the citation, which was denied without any substantive explanation. Second, I'm happy to have my case heard by a judge because I believe the HOA is overreaching its authority. I'm splitting firewood on my own property during reasonable hours in a way that doesn't violate any actual laws or ordinances. This is normal property maintenance, not a violation of community standards." One of the homeowners, a guy named Jeff who lived 2 streets over, spoke up. "I've got to say, I'm with Quentin on this one. I mean, splitting firewood, that's pretty normal stuff. Are we really going to start policing what people can do in their own backyards?" Another homeowner, Martha, chimed in. "How is this any different from someone mowing their lawn? That makes noise too." Patricia's face reddened. "Lawn mowing is necessary property maintenance. Splitting firewood is a choice. So is having a wood-burning fireplace," I countered. "Which, I might add, was a selling feature of this house when I bought it. The listing specifically mentioned the wood-burning stove as an amenity." Roger Chen, the vice president, cleared his throat. "Patricia, may I speak?" She nodded curtly. "I have to say, I'm not sure this is a battle worth fighting. We've consulted with our HOA attorney, and she's indicated that our position is uncertain at best. The covenant language about noise is intentionally vague to cover various situations, but applying it to something as routine as splitting firewood seems like a stretch." "Roger, we've discussed this," Patricia said tersely. "The board voted to proceed. Did we, though?" Susan Rodriguez, the at-large member, looked uncomfortable. "I don't recall a formal vote on whether to fight the lawsuit. We voted on issuing the initial citation, but taking this to court is a different matter." Patricia shuffled her papers. "The board authorized me, as president, to take appropriate action to enforce our covenants." Tom Fitzgerald, the treasurer, spoke up for the first time. "I'm looking at our legal budget here, and we don't really have the funds to fight a protracted legal battle. We'd need to approve a special assessment to cover attorney fees if this goes sideways." The meeting devolved into a heated discussion among the board members and homeowners. It became clear that Patricia had been making decisions without full board consensus, and several people were unhappy about both the situation and the way it had been handled. The meeting ended without any real resolution, but I left feeling like public opinion was shifting in my direction. 2 weeks before the court date, I received a surprising phone call. It was Roger Chen, the vice president of the HOA board. "Mr. Lawson, I hope you don't mind me calling you directly," he said. "I wanted to reach out and see if there was any way we could resolve this situation before it gets to court." "I'm listening," I said cautiously. "Several board members, myself included, feel that this matter has been blown out of proportion. We'd like to propose a compromise. You agree to limit your wood-splitting activities to specific hours, say 10 a.m. to 4 p.m. on weekends, and we'll rescind the fines and drop our opposition to your lawsuit. You dismiss the suit, and we'd add a clarification to the covenant that specifically permits normal property maintenance activities during reasonable hours." It was tempting. It would end the conflict, save me time and stress, and I'd essentially get what I wanted. But something bothered me about it. Roger, I appreciate the call, but I have a question. Why should I have to compromise on something that's already legal and reasonable? I'm already only doing this during reasonable hours. Why should I agree to a narrower window? He sighed. To be honest, because Patricia won't back down otherwise. She views this as a personal challenge to her authority. If you win in court, she'll just find other ways to make your life difficult. At least this way, we get clear guidelines in place that protect not just you but other homeowners from similar overreach in the future. Let me think about it, I said. I'll give you an answer by Monday. I spent the weekend mulling it over, discussing it with Derek, and talking it through with my girlfriend, Wendy. Wendy Lancaster and I had been dating for about 8 months, and she'd been supportive throughout this entire ordeal, even though she thought I was crazy for fighting the HOA over something she saw as relatively minor. Look, I get the principle of the thing, she said over dinner Saturday night at her place. But is it worth the stress? Take the compromise, get it in writing, and move on with your life. It's not just about me, though, I argued. It's about what HOAs can and can't do. If Patricia gets away with this kind of overreach, what's next? Can she tell people they can't work on their cars in their own garages, can't play basketball in their driveways? Where does it end? That's a slippery slope argument. Maybe, but it's also a valid concern about property rights. Derek had a different take when I called him Sunday morning. Look, man, I'll support whatever decision you make, but here's something to consider. If you win in court, you get a legal precedent that's much stronger than any compromise agreement. You'd have a judge ruling that the HOA's interpretation of the covenant is invalid. That protects you and sets a clear boundary that the HOA can't cross. A compromise is just an agreement between parties. It can be reinterpreted, challenged later, or applied inconsistently. That clinched it for me. I called Roger back Monday morning. I appreciate the offer, I told him, but I'm going to proceed with the court hearing. This isn't personal against you or the other reasonable board members, but I think this issue needs a clear legal resolution. Roger was disappointed but understanding. I figured that might be your answer. For what it's worth, I think you're right on the merits. Good luck in court. The day of the hearing arrived on a crisp November morning. Small Claims Court in Buncombe County was held in a practical, no-nonsense courtroom with fluorescent lighting and worn wooden benches. I arrived early, dressed in a button-down shirt and slacks, carrying a folder with all my documentation organized and tabbed. Patricia arrived with the HOA's attorney, a sharp-looking woman in her 40s named Linda Kozlowski. They sat up at the defendant's table while I took my spot at the plaintiff's table. Derek had offered to come for moral support, but I declined. I wanted to do this myself. Judge Martin Hendricks entered at exactly 9 o'clock. He was in his early 60s, with gray hair and reading glasses perched on his nose. He had the look of someone who'd seen every kind of dispute imaginable and was impressed by none of them. Case number 2020, 4SC 8847, the clerk announced. Quentin Lawson versus Meadowbrook Estates Homeowners Association. Judge Hendricks looked over the file briefly. All right, Mr. Lawson, this is your complaint. Why don't you start by explaining what brings us here today? I stood up, suddenly nervous but determined. Your Honor, I'm here because the HOA has fined me and attempted to prohibit me from splitting firewood on my own property. This is an activity I've conducted for 3 years without complaint, during reasonable daylight hours, and in compliance with all applicable noise ordinances. I believe the HOA is overstepping its authority and improperly restricting my reasonable use of my property. And Miss Kozlowski, What's the HOA's position? The attorney stood smoothly. Your Honor, the HOA has a duty to all residents to enforce the community covenants that everyone agrees to when they purchase property in Meadowbrook Estates. Mr. Lawson's wood-splitting activities generate excessive noise that disturbs other residents. The covenant clearly prohibits activities that disturb the peaceful enjoyment of neighboring properties. Judge Hendricks looked back at me. Mr. Lawson, walk me through what exactly you're doing. When, where, for how long? I referred to my documentation as I explained. Your Honor, I split firewood in my backyard, which backs up to a tree line. The nearest neighboring home is approximately 100 feet away. I only do this on weekend mornings, typically between 9 or 10 a.m. and noon. I use a traditional splitting maul, not a powered log splitter, and I usually work for 1 to 2 hours at a time. I've kept a detailed log for the past several weeks showing exactly when I've done this work. I submitted my log as evidence, along with photos of my property showing the layout and distances. Has anyone actually complained to you directly? The judge asked. No, Your Honor. The only complaints have come from Miss Henderson, the HOA president. In fact, several of my neighbors have told me they've never had an issue with it. Patricia leaned over and whispered something urgently to her attorney. Miss Kozlowski nodded and stood again. Your Honor, the number of complaints isn't relevant. The covenant doesn't require multiple complaints for enforcement. Maybe not, Judge Hendricks said, but it's certainly relevant to whether the activity is actually disturbing the peaceful enjoyment of the neighborhood. Miss Kozlowski, do you have any actual evidence that Mr. Lawson's activities are creating a genuine disturbance? Noise measurements, complaints from multiple residents, anything besides Miss Henderson's objections? The attorney hesitated. We have Miss Henderson's documentation of the violations, which includes photographs and dates. That's documentation that the activity occurred, not that it was disturbing. Let me ask you this. Does the HOA ban lawn mowing, leaf blowing, hammering? No, Your Honor, but those are necessary maintenance activities. And Mr. Lawson has a wood-burning stove, correct? I see that in the property listing that's been submitted. So splitting firewood is necessary maintenance for his heating system. Miss Kozlowski shifted her approach. Your Honor, there are alternatives. Mr. Lawson could purchase pre-split firewood. The covenant gives the HOA broad authority to regulate activities that impact the community. Judge Hendricks removed his glasses and rubbed the bridge of his nose. Counsel, I've seen a lot of HOA cases come through this court. Too many, in my opinion. And I'll tell you what troubles me about many of them. HOAs sometimes forget that they're not governing a kingdom. These are people's homes, their private property. Yes, there are covenants, and yes, those covenants are legally binding to a point, but they cannot unreasonably restrict a homeowner's use of their own property. He put his glasses back on and looked at the documentation I'd submitted. Mr. Lawson is conducting a normal, reasonable property maintenance activity during daylight hours, in compliance with all applicable noise ordinances. He's doing it on his own property, in an area that provides substantial distance from neighboring homes. The fact that Miss Henderson finds it annoying doesn't make it a violation. Patricia stood up abruptly. Your Honor, may I speak? Judge Hendricks looked surprised but nodded. You may, but please keep it brief. Your Honor, I've been the president of this HOA for 7 years. In that time, I've worked tirelessly to maintain property values and community standards. Mr. Lawson has been nothing but difficult from the day he moved in. He challenges every rule, questions every decision, and now he's wasting the court's time and the association's money on this frivolous lawsuit. Miss Henderson, the judge said, his tone cooling noticeably. Whether Mr. Lawson is difficult or agreeable is not the issue before this court. The issue is whether the HOA has the authority to prohibit him from splitting firewood on his property, and frankly, based on the evidence I've seen, you don't. He looked down at his notes one more time, then back up at both tables. Here's my ruling. The HOA's citation and fine are invalid and unenforceable. Mr. Lawson is engaged in reasonable use of his private property. The covenant provision regarding noise is meant to address genuinely disruptive activities, parties, commercial operations, things of that nature. It cannot reasonably be interpreted to ban normal property maintenance like splitting firewood during daytime hours. I felt relief wash over me, but the judge wasn't done. Furthermore, I'm ordering the HOA to refund any fines that Mr. Lawson has paid, though I note from the record that he hasn't paid any. The HOA is also enjoined from any further attempts to prohibit this specific activity. Mr. Lawson, that doesn't give you carte blanche to be unreasonable. Keep doing what you've been doing, reasonable hours, reasonable frequency. Don't abuse this ruling. I understand, Your Honor. Thank you. As for attorney fees, Judge Hendricks continued, normally each party bears their own costs in small claims. However, I'm awarding Mr. Lawson his filing fees and reasonable costs in the amount of $400. The HOA brought this on themselves by refusing to be reasonable. Ms. Kozlowski stood quickly. Your Honor, we'd like to request a stay of that order pending appeal. You can certainly appeal if you wish, Counselor, but there will be no stay. This order is effective immediately. We're adjourned. The gavel came down, and it was over. I gathered my papers, feeling a strange mix of vindication and exhaustion. Patricia stormed out of the courtroom without looking at me, but Miss Kozlowski approached with her hand extended. Congratulations, Mr. Lawson. For what it's worth, I advised the board to settle this. They didn't take my advice. I appreciate your professionalism, I said, shaking her hand. Outside the courthouse, I called Derek immediately. He whooped when I told him the outcome. That's fantastic, and he awarded you costs. That almost never happens in small claims. The judge must have been really annoyed with the HOA. He definitely didn't hold back. Patricia tried to speak up, and he basically shut her down. How's she taking it? About as well as you'd expect. She left pretty quickly. Watch your back, man. Sore losers sometimes try to find other ways to retaliate. Derek's warning proved prescient. Over the next few weeks, I noticed a marked uptick in HOA scrutiny of my property. I received a citation for my trash cans being visible from the street, even though I'd put them out on the correct day at the correct time, just like always. Another citation arrived claiming my grass was too long, despite the fact that I'd mowed 3 days earlier and it was well within the covenant's height requirements. Each citation required a written response, supporting documentation, and the hassle of dealing with Patricia's increasingly petty enforcement actions. It was clear she was retaliating for my court victory, trying to make my life difficult through death by 1,000 cuts. I documented everything meticulously. Each citation, each response, each instance where I could prove compliance with the actual covenant requirements. After the 5th frivolous citation in as many weeks, I'd had enough. I called Derek again. She's clearly retaliating, Derek said after I'd explained the situation. That's actually actionable. Selective enforcement and retaliation are prohibited under North Carolina HOA law. We could file another suit for harassment, but there might be a better approach. What's that? Go over her head. Call for a special meeting of the HOA membership to recall her from the board. You'd need 20% of homeowners to petition for the meeting, but from what you've told me about that board meeting you attended, you might be able to get that support. I spent the next weekend going door to door in the neighborhood, talking to people I'd never really spoken with before. I explained the situation, showed them copies of the court ruling and the frivolous citations I'd received since then. The response surprised me. More than half the people I talked to had their own stories of unreasonable treatment by Patricia. There was Mike, who'd been fined for having a decorative garden gnome that was supposedly not in keeping with community aesthetics. There was Rachel, who'd fought a year-long battle over the color she wanted to paint her shutters. There was elderly Mr. Peterson, who'd been cited for having a portable wheelchair ramp installed on his front steps. Within a week, I had signatures from 35% of the neighborhood homeowners, well more than the 20% required. I submitted the petition to the HOA board, and a special meeting was scheduled for 3 weeks out. The meeting was packed. Every seat in the clubhouse was filled, with people standing along the walls. Patricia sat at the head table, flanked by the other board members, looking defiant. Roger Chen looked uncomfortable, while Susan Rodriguez and Tom Fitzgerald seemed resigned to what was about to happen. I'd been elected to present the case for recall, standing at the front of the room with a prepared statement. "Thank you all for coming tonight," I began. "We're here because a pattern of behavior by our HOA president has created an environment where homeowners feel harassed, intimidated, and unable to reasonably enjoy their properties. This isn't about any single incident. It's about a systematic abuse of authority." I went through the examples methodically. My court case and the subsequent retaliation, Mike's garden gnome, Rachel's shutters, Mr. Peterson's wheelchair ramp, the special assessments that had been approved without proper notice, the selective enforcement of covenant provisions. By the time I finished, the mood in the room had shifted from uncertain to angry. Patricia demanded the chance to defend herself. She stood at the head table, gripping its edge with white knuckles. "Everything I've done has been in service to this community," she said, her voice shaking slightly. "I've dedicated 7 years of my life to maintaining our property values and standards. If some people find that inconvenient, that's not my problem. I was elected to enforce our covenants, and that's exactly what I've been doing. Even when a judge rules that you're wrong." Someone called out from the audience. Patricia's face flushed. That judge was wrong. He didn't understand the importance of maintaining community standards. Roger Chen stood up beside her. "Patricia, I think you should stop talking." "No. These people need to understand that someone has to make the tough decisions. Someone has to be willing to enforce the rules, even when it's unpopular." The vote wasn't even close. 87% of the homeowners present voted to recall Patricia from the board. She left the meeting in tears, and Roger was elected as the new president later that evening. One of Roger's first acts as president was to propose amendments to the covenant that would clarify the noise provisions, protect reasonable property maintenance activities, and create an appeal process with neutral arbitration for disputed violations. The amendments were put to a vote at the next quarterly meeting and passed overwhelmingly. Life in Meadowbrook Estates improved dramatically after that. The new board was reasonable, responsive, and focused on actual community needs rather than petty enforcement actions. I continued splitting firewood every Saturday morning and nobody complained. About 6 months after the recall, I ran into Patricia at the grocery store. She was in the produce section, and our eyes met over the tomatoes. For a moment, I wasn't sure what would happen. Then she surprised me. "I owe you an apology," she said quietly. I set down the avocado I'd been examining. "I'm listening." I got caught up in the authority of the position. I convinced myself that every rule had to be enforced rigidly, that any flexibility would lead to chaos. I made your life difficult because you challenged me, and I couldn't stand being challenged. She paused, looking down at her shopping cart. My husband told me I'd become someone he didn't recognize. I've been seeing a therapist, working on understanding why I needed that control so badly. Patricia, I appreciate you saying that. I never wanted to make things personal. I just wanted to be able to use my property reasonably. You were right. The judge was right. Roger's doing a much better job than I ever did. I just hope someday the neighborhood can forgive me for being such a... She trailed off. We all make mistakes. The important thing is learning from them. She nodded, gave me a small, sad smile, and walked away with her cart. I felt a strange sense of closure watching her go. The following winter was one of the coldest on record for Asheville. I was grateful for every cord of firewood I'd split, and my wood-burning stove kept my house warm and cozy through the bitter January nights. Wendy and I spent many evenings curled up in front of that fire, and I couldn't help but reflect on how different things might have been if I'd just backed down from Patricia's initial demand. One Saturday morning in early February, I was outside splitting wood when my neighbor, Jeff, wandered over with a cup of coffee. We'd become friendly after he'd supported me at that contentious board meeting. "Man, I've been meaning to ask you," he said, watching me work. "After everything you went through, was it worth it? All that stress and time and money over splitting firewood." I set down the maul and thought about it. You know, it wasn't really about the firewood. It was about the principle that you don't surrender your rights just because asserting them is inconvenient. If we let HOAs become little dictatorships, where boards can prohibit anything they personally don't like, then homeownership becomes meaningless. You're just renting from the HOA at that point. Jeff nodded slowly. I never thought about it that way, but you're right. Hey, I've got a cord of oak being delivered next week. Think you could teach me how to split it properly? Absolutely. Come by any time. Roger turned out to be an excellent HOA president. He approached the position with humility and a genuine desire to serve the community rather than control it. Under his leadership, the Meadowbrook Estates HOA became what it should have been all along. A helpful organization that maintained common areas, organized neighborhood events, and enforced reasonable standards without making homeowners' lives miserable. The legal precedent from my case also proved valuable beyond just my situation. Derek told me that several other attorneys in the area had cited Judge Hendrick's ruling in subsequent HOA disputes, and it was contributing to a broader shift in how HOAs approached enforcement in Buncombe County. Boards were being more careful about distinguishing between genuine violations and normal property use. Wendy and I got engaged that spring. We'd been looking at houses together, and she asked me half-jokingly if I was sure I wanted to live in another HOA community after everything I'd been through. As long as the board is reasonable, HOAs can actually be fine, I told her. It's when you get people like Patricia who are more interested in power than community that things go wrong. We just need to read the covenants carefully and make sure we're comfortable with what we're agreeing to. We ended up buying a house in a different Asheville neighborhood, one with a much simpler HOA that basically just maintained the entrance landscaping and organized an annual neighborhood picnic. The covenants were brief, reasonable, and hadn't been updated since 1987, which I took as a good sign that nobody felt the need to keep adding restrictions. I kept my old house in Meadowbrook Estates as a rental property. The tenant who moved in was a young professional who worked from home and loved the wood-burning stove. I made sure to mention the history with the HOA during the lease signing, but she just laughed. Sounds like you stood up for yourself and won. Good for you. Looking back on the whole experience, I learned several important lessons. First, read your HOA covenants carefully before buying a property and make sure you understand what you're agreeing to. Second, document everything when dealing with an HOA dispute. I probably had more documentation than necessary, but it all contributed to presenting a clear, organized case in court. Third, don't be afraid to stand up for your rights, even when it's easier to just give in. But perhaps the most important lesson was about community. The whole dispute could have fractured the neighborhood, creating bitter divisions that lasted for years. Instead, it ended up bringing people together. Homeowners who had never spoken to each other before bonded over shared frustrations with HOA overreach. New friendships formed. The board became more responsive and less autocratic. In a strange way, Patricia's unreasonableness catalyzed positive change for the entire community. I still split firewood on Saturday mornings, whether at the old house or the new one. The sound of the maul striking wood, the smell of fresh cut oak, the physical satisfaction of the work, these simple pleasures were worth fighting for. Not because they're essential to survival in the modern world, but because they represent something larger. The right to live your life on your own property without unreasonable interference. Every time I stack a new cord of split wood, I think about that day in court, Judge Hendrick's ruling and the principle he upheld. Property rights matter. Reasonable use matters. And sometimes, you have to be willing to stand up and fight for what's right, even over something as seemingly simple as splitting firewood on a Saturday morning. The firewood dispute became something of a local legend in Asheville. A reporter from the local paper did a story about it titled "HOA Board Gets Schooled by Judge in Firewood Feud," which got picked up by a few national outlets. I did a couple of interviews, always emphasizing that I wasn't anti-HOA, just pro-common sense. The attention embarrassed Patricia, who had moved to a different neighborhood by then. But it also served as a cautionary tale for other HOA boards about the importance of reasonable enforcement. Derek framed a copy of Judge Hendrick's ruling and hung it in his office, telling me it was one of his favorite cases even though he'd barely done any work on it. "You represented yourself and won on principle," he said. "That's the kind of case that reminds me why I went into law." Years later, I still get occasional emails from homeowners in other states facing similar HOA disputes. They find my story online and reach out for advice. I always tell them the same thing. Document everything, know your rights, be reasonable in your own conduct, and don't be afraid to take it to court if necessary. The system isn't perfect, but judges generally don't like HOA overreach, especially when it comes to normal property use. My relationship with the Meadowbrook Estates, HOA, remained cordial after Roger took over as president. He implemented policies that balanced community standards with homeowner rights, and the neighborhood thrived under his leadership. Property values actually increased more in the years after Patricia's departure than they had under her strict regime, suggesting that overly aggressive enforcement doesn't necessarily protect values the way some board members believe. The wood-burning stove in my old house kept working beautifully, heating the space efficiently and providing that irreplaceable ambience of real fire that gas logs can't match. My tenant renewed her lease multiple times, partly because she loved that stove and partly because, she told me, she appreciated living in a neighborhood where the HOA had learned to be reasonable. As for Patricia, I heard through the neighborhood grapevine that she'd done genuine work on herself after the recall. She volunteered at a local animal shelter, reconnected with old friends she'd neglected during her years of HOA obsession, and reportedly became much happier overall. Sometimes losing power is the best thing that can happen to someone who's been corrupted by it. The amendments to the Meadowbrook Estates covenants that Roger championed became a model for other HOAs in the area. Several neighboring communities adopted similar language, clarifying that normal property maintenance and reasonable use were protected activities. The Buncombe County Bar Association even did a CLE presentation on HOA covenant interpretation, using my case as an example of proper judicial restraint of HOA authority. On quiet Saturday mornings now, when I'm splitting wood at my new house, I sometimes pause and listen to the sounds of the neighborhood. Someone mowing their lawn 3 houses down, kids playing basketball in a driveway, a dog barking, someone hammering together a deck project. These are the sounds of people living their lives, using their properties, making their houses into homes. That's what Patricia never understood. A neighborhood isn't made better by silence and strict uniformity. It's made better by allowing people to actually live in their homes, to pursue their hobbies, to maintain their properties in reasonable ways, and to be part of a genuine community, rather than subjects of a petty tyranny. The firewood I split now heats my home through cold winter nights. Wendy and I sit by the fire with our evening coffee, planning our future, grateful for our home and the reasonable HOA that governs it with a light touch. The wood stove crackles and pops, the heat radiates through the room, and I'm reminded that sometimes the simplest pleasures are worth fighting for. I never set out to be an activist or a test case. I just wanted to split firewood on my own property. But in defending that simple right, I helped clarify the boundaries of HOA authority and reminded everyone involved that property ownership means something. It means having reasonable control over your own space. It means being able to maintain and use your property without arbitrary interference. It means that even in a community with covenants and rules, individual rights still matter. Judge Hendricks got it exactly right in his ruling. Reasonable use of private property isn't just a legal principle, it's the foundation of homeownership itself. Without that, you don't really own your property at all. You're just a tenant with extra responsibilities and a mortgage, so I keep splitting wood, following the rhythm my grandfather taught me years ago. Drive the wedge, strike true, let the grain guide the split. It's honest work, satisfying in its simplicity. And now, thanks to a judge who understood the importance of property rights and a community that came together to demand reasonable governance, it's work I can do without looking over my shoulder for the HOA president's car slowly driving past to document my supposed violation. The mall rises and falls, wood splits and falls away, and life goes on in this small corner of Asheville, North Carolina, where one man's fight over firewood helped restore a bit of balance between community standards and individual freedom. Sometimes the smallest battles establish the most important principles. Sometimes standing your ground over something as simple as splitting wood on a Saturday morning is exactly what needs to be done. And on cold winter nights when the fire burns bright and warm, I'm glad I fought that fight. Not just for myself, but for every homeowner who came after me, and for the principle that your home really is your castle, even if it happens to be in an HOA.